Hi, I'm Prasad. I'm an advocate practicing most of my time in High Court of Telangana and all the subordinate courts in Hyderabad. Today, I'm going to share with you about the remedy you need to seek when the check bounce case is launched against a company having more than two directors. And if the complainant pleads in the complaint that all the directors have a role to play in issuing that check, all the directors has the financial responsibilities in discharging the amounts that are involved in the day-to-day business of the company. All the directors are in charge of the financial matters of the company, are responsible for the financial matters of the company, are responsible for the loans and liabilities of the company. If that kind of pleading is adopted by the complainant very carefully after getting information or after getting knowledge from the Honorable Supreme Court's judgment pertaining to the subject which I am speaking right now in Ganmala sales case rendered on 18th October 2014, then what is the remedy you need to seek is what I am going to share with you right now. Now, when a company is issuing the check, who could issue a check in the company? The MD could issue a check in the company, or any other director could issue a check in the company, or any other authorized signatory could issue a check at the company, or two authorized signatories could issue a check in the company. Generally, two authorized signatory in companies which are large in size, the authorized signatories will be two in number. They will issue the check in the company. If they issue the check for the company after getting authorization from the board, and if that check gets bounced, and along with them, they anyhow will be made as the party because they signed the check. Along with them, all the directors have made parties of the parties to the case, check bounce case, along with the managing director of the case. Undoubtedly, managing director will be made a party to the case. Now, if all the directors are made parties to the case, what is the remedy the company and the other directors will have? Can the directors approach the Honorable High Court for quashing the complaint? Is what that was explained in Ganmala's case, Ganmala sales case. Supreme Court categorically created the principles and the guidelines to deal with this kind of circumstance and the guidelines to quash the complaint. In what circumstances Supreme Court will quash the complaint? The circumstances that the accused should present before the Honorable High Court should be unimpeachable and uncontrovertible. This is the expression that was used. What is the meaning of unimpeachable and uncontrovertible circumstances that has to be presented before the Honorable High Court for quashing the complaint? Is that the circumstance should be beyond doubt. Beyond maximum doubt, the circumstance should be available. For example, what kind of circumstance will be beyond doubt? Suppose a director resigned from the company and a check is issued after the resignation of the director from the company, and that director name was roped in the company, and can the director come to High Court to quash his name in the check bounce complaint? And the answer to this is yes. This kind of circumstance that attracts the expression unimpeachable and uncontrovertible. So there could be many circumstances, because once a director is resigned, that information will be shared with the regulatory body, that is the company law board. And if the resigned director could bring to the Honorable High Court that piece of certified copy from the regulatory body of the government, that is the company law board, then High Court could consider. That will be unimpeachable and uncontrovertible. So the circumstance that the accused director or anybody in the company who is in charge of the company, sometimes accountants are made parties as the company, sometimes secretaries are made parties of the check bounce case, because complainant is having the luxury of making all of them as the parties of the case, because every person who is in charge of the company was the expression that was used in section 141 read with 138 of companies in the check bounce case. So therefore, complainant will have the luxury of making the MD as a party. If MD issues the check, there is no problem, because MD is the managing director, and the expression managing director itself proves that he is managing the affairs of the company. So the point what Supreme Court created here is, the principle what Supreme Court created here is, they should be in charge and responsible for the affairs of the company. And if they may not be in charge or responsible for the affairs of the company, but if the complainant is making a plea, taking the pleading that they are in charge and responsible for the affairs of the company, court will consider that fact, because it is a deeming provision. Again, The word deemed is used in section 141. Therefore, the quash petition will not be maintainable in that kind of circumstance. They have to suffer trial, and in the trial they can come out. That they have to prove in the trial that they are not in charge and responsible for the financial affairs of the company. They don't have any role in planning to prepare the check, or in planning to issue the check, or in managing the funds, or in getting the loans, because the financial aspect of a company is seen by the separate individuals. All those individuals only will know whether this check can be issued, or will this check get bounced or not. Other area of a company could be, if it is a manufacturing, if a director is in charge for manufacturing operations, he will not know about the financial transactions of the company, because managing, marketing, manufacturing, accounts, there will be many departments in the company. Because you can't make all the directors of a company as a party in the check bounce case, but complainant is having the luxury of making all of them as a parties as in the check bounce case, because based on that pleading, it is a deeming provision. Based on that pleading, court will accept and issue the process. Now it is for them to discharge. That is for them to discharge the burden of disproving the allegations of the complainant, disproving the averments of the complainant. So therefore, if at all the directors who are not at all involved in the financial transactions of the company are made parties in a check bounce case, they have to bring forth uncontrovertible and unimpeachable evidence to the court to get the complaint quashed against them under section 482 of Honorable High Court, which has the inherent powers to quash any sort of proceeding that is launched by the complainant in a criminal case. In a criminal case under section 482 of the Criminal Procedure Code, High Court has the power to quash the complaint. So if the check bounce case, if the director wants to quash the check bounce case pertaining to his role, pertaining to him itself, then he has to bring that kind of very strong evidence which is beyond doubt, and High Court will consider that decision is what the principle that was enunciated and culled out in the Ganmala sales case. Therefore, nothing to worry if you are not involved in the financial transactions of the company, if you are not involved in the daily operations of the company, if you are not involved in the affairs of the company, if you are not involved in the responsible position of the company, and still made a party by the complainant, but you have to suffer the trial. If an allegation is made, you have to suffer the trial. Nothing can be done about that. Complainant will have the luxury of making the allegations in a check bounce case. Be very careful while issuing the checks. That itself is the message that Supreme Court wants to send across the country pertaining to the check bounce cases, because check bounce cases will affect the economy and smooth running and functioning of the economy, and therefore Supreme Court and the legislature and the government are taking these cases very seriously. Thank you. Thanks for watching. Bye-bye.